We're going to move the discussion on, thank you, Rabbi, to non-disclosure agreements. Before we do that, we're going to roll the tape and show a little clip related to a recent ongoing saga impacted and caused, really, by non-disclosure agreements. Please.
The recent avalanche of sexual harassment allegations has cast a spotlight on non-disclosure agreements. These are the contracts employers use to keep such matters private. Jerika Duncan has more on this.
I signed that non-disclosure agreement. And, I think at the time I hoped, I'm just going to close my eyes and just make this go away.
But that's not what happened for former Fox News anchor Juliette Huddy. She's one of several women who reached settlements with 21st Century Fox over sexual harassment allegations involving former Fox News host Bill O'Reilly.
I also was concerned that I would be called a liar, and it was going to be my word against somebody who was very, very powerful.
What was your understanding of non-disclosure agreements?
Both sides keep your mouth shut.
Using non-disclosure agreements is a common practice. They're generally used to help protect confidential information within companies. But in the wake of growing sexual misconduct claims, we've seen how they can be used to keep those claims a secret. Across the country, at least 6 states have recently proposed legislation to ban or place limits on workplace non-disclosure agreements in cases involving sexual harassment or assault.
This took a lot of work.
And this week, bipartisan legislation was introduced on Capitol Hill that would eliminate forced arbitration, which prevents sexual harassment victims in many cases from going public and going to court. For Juliette Huddy, she says in retrospect, signing the NDA was a bad idea.
The tears are coming because I'm upset with myself for not dealing with it. And again, potentially preventing him from doing something else to somebody.
Very, very powerful, very disturbing on a lot of different levels. Rosemary, the role of non-disclosure agreements, as was mentioned in the video, has changed somewhat over time and is being used in different contexts. What role should it have within the context of doing business, and what's kind of going a little bit too far?
Well, I don't think the role of confidentiality agreements in employment cases has changed that much during the time that I've been practicing. It's commonly used, has been a widespread practice in employment discrimination cases. I think there are 2 different problems here. A lot of bad things are being attributed to non-disclosure agreements that are not necessarily the fault of the non-disclosure agreements. There is a move federally and in a lot of states to do away with non-disclosure agreements in the current political climate. I think that probably is going to happen. I think it's a mistake. I think that the result of doing away with non-disclosure agreements means that many more cases are not going to be settled. Many more cases are going to be litigated. And you have to understand that the vast majority of sexual harassment cases are not the Harvey Weinsteins and Charlie Roses of the world. The vast majority of them are much more minor incidents of sexual harassment. All sexual harassment is bad. I'm not saying it isn't. But in many cases with lesser accusations, especially when you have a senior executive or a management employee named in the complaint, there's not going to be a settlement if there's not a non-disclosure agreement. If the individual insists and has a reasonable chance of proving that the harassment didn't occur, because he's going to feel like he or she, because sometimes the accusers are men, are going to have to litigate the case out, are going to have to go to trial to clear their name instead of having it on record in the public, on PACER, that they settled a sexual harassment claim. The problem in a lot of the situations where non-disclosure agreements are being given all of the blame is partially something else. The fact that you settle a case involving sexual harassment doesn't mean the employer doesn't have a responsibility to make certain that action is taken against the harasser and that effective steps are taken by either terminating or disciplining or having some kind of supervision within the workplace to make certain that that harassment doesn't continue. Now, that's a separate obligation that's totally apart from the non-disclosure agreement. So the fact that you settle a case with an NDA doesn't absolve the employer from that separate obligation.
But hasn't history shown us that people have stayed in power and continued to reoffend and have kind of used these NDAs as a way to cover up the problems and move on to their next victim?
I think that in some of the examples that we've seen in the news, certainly that has happened. But again, you know, I don't think that we should throw out the baby with the bathwater. I think that the practical effect in the vast majority of sexual harassment cases is you're not going to see settlements, you're going to see people insisting upon litigating their cases through trial. And I think that there are other ways of addressing the serious problem where you've got serious harassers being allowed to remain in the workplace.
Neil, you agree?
No, I respectfully disagree.
Really?
It's a complicated issue. The legislation that's pending in New Jersey, having passed the Senate, speaks of not permitting non-disclosure of the underlying facts, essentially, of discrimination. I disagree with Rosemary that these confidentiality and non-disclosure agreements haven't changed. They have changed. It used to be that we just could not disclose the amount of the settlement. Then they grew broader and broader. You couldn't disclose the underlying facts. Then they grew even broader. We had to turn over the documentary evidence to the other side, or we had to destroy the documentary evidence. You'll see some of these clauses in recent litigation in the O'Reilly case in the Southern District of New York, where the judge revealed these settlement agreements. So they become extremely onerous, extremely oppressive. I agree with the legislation that's pending in New Jersey now in the lower house that would bar non-disclosures of the underlying facts. I think the light of day is essential here. There is a patriarchy. It's not just a phrase. Men dominate corporations. Men dominate law firms. Men dominate the courts. Men dominate the Congress, the legislatures. So how do we break through? We might suffer some bumps in the road as plaintiffs' lawyers. We might not get the settlements we used to get. So what? The purpose the Supreme Court of New Jersey has said of the LAD is to eliminate the cancer of discrimination, to eradicate it. It doesn't matter what happens to the lawyers' bottom lines. That's irrelevant. If we shine the light of day, as is happening again in certain religious institutions, if we shine the light of day, then I think we can begin to eradicate for the first time this massive problem of sexual harassment. It might cause some bumps in the road in litigation. I say, so what?
So Karen, let me turn to you for a second, because sunlight is the best disinfectant, there's no question about that, and it's good for cases to get out and for people to be outed and be called out on inappropriate behavior. But then you have the media, and then you have stories going out into the news which impacts the company, impacts the law firm, impacts whatever group it is that actually are either responsible or may not be responsible for what happened. And what happens to everyone's bottom line then? What happens to the careers of all the people working for you? Is there a place for privacy, for non-disclosure agreements, to avoid certain cases going out into the media, especially in a frenzied environment we find ourselves in, that could literally destroy a company very, very quickly?
Well, there's no doubt that the employees deserve to have their jobs and that they should not have to bear the burden of a CEO or of senior management that was behaving in such a fashion. And that's very important, and obviously that's part of what we get involved with when we walk in, is to make sure that those employees do have a life and that there is going to be a career for them when this is over. That being said, when the media does begin to look at these companies, and the media, I think at this point, has been fairly responsible about reporting on the fact that these are usually not company-wide policies, unless it's a small company where everybody was joining in. These are usually parts of what was going on at the most senior levels of management. Senior levels of management now, as opposed to before, used to be the women were asked to leave. Now more and more, not all the time, the men are being asked to leave. More and more board members are turning over, as we saw in the case of CBS, so that they will now have 6 new board members as opposed to what they had in the past. But that doesn't mean that people are not going to have careers. And in fact, in some ways, sometimes after this is over, this purge, people say, you know what, that's an employer that I want to work for, and it actually becomes a positive, and they're able to recruit people because women feel like maybe I'm going to get a shot at having a career in some of these companies where I didn't have one before.
Could you envision a scenario where an NDA would be appropriate, or where you would recommend a client of yours, you know what, it's not a bad idea to use a non-disclosure agreement?
Well, I think listen, I think even in this law that's being contemplated in New Jersey, it's not that there never will be one ever for anyone at all. I think that on behalf of these victims who oftentimes don't want to have their whole story told, they will have the right to be able to say, I still don't want to have my name out there, I still don't want to be known as that person, and I think that that's what smart legislation is about. But I do think in the case of Weinstein, which was the first time we saw someone break an NDA in a very public fashion, what we saw was everybody assumed, you know, and as even, I know you don't want me to get political, but even with our president who's threatened about, you know, I'm going to go after people, is they're hollow threats. Because once a case is high profile enough and the media's paid attention, when these NDAs are broken, nobody's really going to go after them because that creates just another whole cycle of bringing the story out yet again. But it doesn't take an NDA. I mean, we saw in the case of Eric Schneiderman, he didn't have an NDA with those women, but they still were petrified to come forward. It's about power. It's really not about their legal handcuffs.
Rabbi, let me ask you a question. One of the things you mentioned several years ago when Judge Napolitano was moderating our panel, you mentioned that Jewish law prohibits gossip, and he found that quite astounding. Just in case you were not paying attention, Jewish law prohibits gossip. It's hard to believe. It's not even on our list on Yom Kippur. We're not even thinking about that. That's okay. But there is a concept in Jewish law called lashon hara, speaking ill about someone else and saying bad things about another person, items that are true. One is not allowed to say bad things about another person. It falls under the prohibition of lashon hara. How does the non-disclosure agreement, which seemingly would be upheld by that principle of let's keep this quiet. Yes, the people should be punished for the things they did wrong, but we don't need to go public. We don't need to share bad information about other people. What do you say to people that would give you that argument?
So when it comes to both slander, lashon hara, speaking ill, and confidentiality, Jewish law is essentially in a binary state. It's digital, which means to say, if it's negative about another person, you may not say it even if it's true. This may be where British law got its truth is not a defense against libel thing. Even if it's true, you may not say it. Conversely, if this piece of information, the withholding of it, the not sharing of it could hurt someone financially, emotionally, physically, etc., you are obliged to say it, and you may not remain quiet. The depth, shall we say, of transgression before Yom Kippur, might as well know what transgressions are. The depth of transgression in speaking ill of someone where it doesn't help a third party is equal to the sin of not speaking up where it does help a third party. So that, and the same thing with confidentiality. You don't need an NDA. Under Jewish law, and I know this will come as a shock to everyone, you may not repeat anything someone told you or any information about someone's life that is somewhat privileged without their permission, without any agreement. But if there's a third party involved, you can make all the agreements you want because it's a Jewish law that you cannot make an agreement to create a liability for a third party.
Can you give me a practical example, please?
I was getting there. The practical example is quite simple.
Let's get there quicker, right?
It's quite simple. That if you make an agreement with someone not to share information, that the withholding of that information could harm a third party, it exposes someone to theft, to swindling, to embarrassment, you're not allowed to withhold that information, and the agreements are not worth the paper they're written on under Jewish law.
Okay, perfect. Thank you very much. One last question on NDAs before we move on to our third and final topic for the evening. Someone that's already signed a non-disclosure agreement and someone that's already received their settlement, and now they want to speak up. They're at risk of losing whatever settlement they had or litigating it all over again. What do you recommend? Someone comes to you and says, Rosemary, Neil, Karen, Rabbi, I signed an NDA many years ago. No one knows about this. I don't know what's happened at the company since, but I kind of feel, like the rabbi said earlier, I feel this moral obligation to speak up, but I don't want to have to deal with giving back my settlement. Neil, what do you say?
We honor all non-disclosure agreements we have signed. We've never violated a non-disclosure agreement in our 38 years of practice.
Would you advise someone break an NDA?
I would never advise anyone to do it. I think it's wrong, and we've seen examples of that on the media recently. That said, I want to eliminate non-disclosure agreements. There's a myth out there in the media. That women really want non-disclosure agreements. I can say that we have never had a woman ask for a non-disclosure agreement. I mean, ever. Women don't want non-disclosure agreements. They're surprised and disgusted and horrified when they see the draft of the settlement agreement. It requires them to shut up. There's another issue. It's a moral issue, maybe a Talmudic issue. I don't know.
Well, let's find out. Here we are, right?
Let's find out. And I wonder about this. Because when you have a system like we have now, you're involved in the buying and selling of secrecy. A lawyer on the defense side buys secrecy from me, and we sell it. And sometimes the secrecy involves things the public should know, not just whistleblowers about sexual harassment. I had a case forced into secret arbitration recently involving a medical device that killed 13 people. I made a motion in the arbitration to release it to a plaintiff's firm that had no idea about my case and the testimony. And the three-member panel said, no, arbitration is secret. So we represent whistleblowers about dangers to the public, not just victims of sexual harassment. And yet when these cases settle, there are non-disclosure agreements. So the problem is much graver, as grave as the sexual harassment non-disclosure is. We have whistleblower statutes, and whistleblower cases are being settled in secrecy or tried in secret corporate arbitrations. So is it moral? Is it just for a lawyer to sell secrecy and for a defense lawyer to buy secrecy on behalf of the client? Is there some analog in the Talmud?
Rabbi?
Well, the analog in the Talmud about a medical device that's killing people would be that anyone who creates or participates in such an agreement is an accessory to murder. We don't execute accessories to murder, but they're an accessory to murder. Now let's get back to our topic. In our topic, I would suggest...
Neil, the media will be outside at the end of the program.
Rabbi, I didn't hear an answer yet. I heard a partial answer.
The media will be here, and you'll let them know everything.
From the perspective of Judaic law, again, given that sexual harassment is treated very seriously, in the event that this was not a indiscretion, a weed that suddenly flowered, but it's a whole forest of weeds, it's a whole lot full of weeds, which means to say this is someone who has harassed and will harass again. There's a pattern of bad behavior. Such an agreement may not be made and may not be enforced. Under Judaic law, it's impossible that we should allow someone to keep on endangering the vulnerable, in this case, women in this workforce, under any circumstances. No Judaic law would not allow such an obscenity of this type of agreement to be made in such a case.
Karen, what would you tell someone that wants to break a non-disclosure agreement and risks losing their settlement? What advice would you give them?
So here's the hard, cynical truth, which is in very high-profile cases with very high-profile people, when you break an NDA and you decide to go out there, the risk is less because the media is more attracted and you have protection by being in the media's eye. And unfortunately, it's just the way it works. But if you're going to go out and break an NDA because you're working at a drugstore chain and you're going to go after the guy who was your boss, who was the manager of the drugstore, you're going to get killed for it, and you're going to, they're going to come after you, and you're going to, yes, you're going to lose the money, and yes, there's going to be litigation, and yes, there's going to be penalties because you signed an agreement saying you wouldn't. And it's unfortunate, and it may not be fair, but it is indeed the way the world works, which is why women were allowed, not allowed, but why women that broke it for Harvey Weinstein were able to proceed without being any kind of problem, and why women that broke it for, Jeff Fager, for example, from 60 Minutes, and that's why you don't see it very often. You only see it in those cases, and only, frankly, very recently when there's been enough press attention.
Rosemary, when is it appropriate to break an NDA? Is it ever?
Well, I would agree with the first part of Neil's answer, is that if I have a valid agreement, entered into at a time when non-disclosure agreements were valid and enforceable, then I don't think it's valid to break that agreement. I'd like to add that most non-disclosure agreements specifically permit the person to go to governmental agencies, so that you do have, it's not a total bar to disclosing information, because the individual entering a non-disclosure agreement isn't prohibited from testifying honestly if they're subpoenaed in a proceeding. They're typically not prohibited from going to the Equal Employment Opportunity Commission. They are prohibited from going to the New York Times.